I can't even get through my initial questions here because you are being so obstructionist.
That's because you're a weak lawyer, but go ahead. You sued me for fraud. Ask me fraud questions. You sued my firm for fraud, aiding and abetting, and conspiracy. You have no evidence. Put something in front of me and we'll answer the questions. You have nothing. You have nothing.
Mr.
Put
Abrams,
something in front of me.
are you aware that Judge Starrs already ruled that there is substantial evidence against your firm that you committed fraud?
Object to
for misrepresentation of the evidence,
you aware?
Mischaracterization. The fact that the judge let you bring your bogus claim against us doesn't mean that it's merit full.
Welcome to another edition of the Litigation Psychology Podcast, brought to you by Courtroom Sciences, Inc. I am Dr. Steve Wood, and what a better way to start off the show than with what's likely an attorney's worst nightmare. You spend all this time prepping your witness in order for them to give good testimony. And then as we saw in the video, the witness goes completely off the rails and has an emotional meltdown. And that's what we're going to talk about today. We're going to talk about emotional witnesses and preparing them for deposition. Here to help me talk about that is attorney Matt LaBeau. Matt, how are you?
Good. How you doing?
I'm good. Thanks for joining the show. Hey, can you just kind of give the audience a little bit of overview about, what your office does, who you work for, and kind of what your area of expertise is?
Sure. Our firm is for the most part a defense firm, and we do a number of different practice areas. And mine is much geared towards auto and general liability, and so it ends up being a lot of defending insurance carriers or their insureds when they get sued, or you might have homeowners getting sued or contractors getting sued, that sort of thing. Defending them, in litigation like that.
Okay, and I see actually reading your bio that you were actually named as a rising star from 2012 to 2020, correct?
Yeah. I don't know when my star's been rising for a few years here. I don't know when it's going to get to the top, but it'll get there.
Well, it definitely then goes to show that you'd be good to talk to this then. So in your experience, how has it been preparing these emotional witnesses for deposition?
If you know about it beforehand, it's not bad. It's just a lot of work. If sometimes though, you have witnesses, they can be sad, kind of tearful sort of thing because they're upset that it happened. You could have folks that they get pretty angry because they've been sued. And then, you also get the folks that are real nervous, kind of intimidated. And sometimes those emotions don't pop up till they're in the chair. But if you know beforehand, it's like I said, it's just kind of a good amount of work. This topic really, when this was introduced to me, the topic, I have this one witness that just absolutely comes into mind. When you talk about emotional witnesses, I had a case where this young woman in her early 20s was heading to her new job in Chicago, and on the highway, a guy in a motorcycle wipes out in front of her, and she ends up hitting the guy. Mm-hmm. And she's very upset about it happening. She had psych treatment and needed a lot of therapy to help kind of get her be okay again. And we were able to identify that early on. Her insurance carrier knew about it. We talked about it a lot. And so I knew she was pretty upset about it. So we were able to meet with her several times, and I think we had like a prayer thing before just to kind of help her go. That's what made her tick. And so we got her through it, took some breaks and things like that. But if you don't know about it, it's pretty unsettling. But if you do know about it, you can prep and you can kind of get through it. But it can be tough.
How did that deposition turn out with you taking that approach of prepping and spending a lot of time talking with her and getting that out?
Real well, actually. I mean, there was a couple of times where we got to the point of how the accident happened, and she had to walk out and kind of had to take a break and kind of collect herself. But she afterwards, I think she had her whole family there as it ended up being, and I think she felt okay when it was done, and it went fine. She got through it. Yeah.
Yeah, I think one of the things that is important to keep in mind, right, is a lot of these people are being deposed for the first time. They're scared, they're nervous, they don't know what to expect. And like I said, that's one of the things that we do as well when we're working with attorneys to help, train their witnesses for deposition, is focusing on that and kind of having those therapy sessions, right, before you just launch into going, okay, here's how we're going to do it. Here's how you should testify in the case. Here are all the case facts, like spending that time to really do the human side and understand and work with the witnesses to get them to feel comfortable before they go into deposition, because many of them are going to be deposed for maybe the first and hopefully the only time in their lives. So it's going to be stressful as it is. So what have you found though, as far as, that was a good outcome as far as being able to identify that ahead of time and work with the witness ahead of time. But you got any horror stories? I know we all like to hear the good horror story to help.
Oh yeah.
Yeah.
Oh
so
yeah.
what have you found to be some of the most difficult cases that you've worked on?
Yeah, like the one I just talked about, like the emotional one, that's a lot of work on the front end. But I would say during the deposition, probably the nervous person or the angry person is the tough one. But I think the nervous one is the hardest, because sometimes that creeps up. Sometimes people are doing just fine. I'm great. I'm doing just fine. And I had a witness. She was a representative of an insurance company, like an adjuster.
Mhm.
And she was fine. She's good to go. I prepped her for several hours, and I think she maybe wasn't as prepared as she thought she was. She sat down in the chair. It was on video, and I think that worried her as well. And I have to tell you, I mean, we had a great defense. We had a great case. I think we could have tried it and won 8 or 9 times out of 10. And she sat down in that chair and was like I said, stone face, and pretty much gave the opposing counsel whatever they wanted in terms of an answer. And they were respectful. They weren't mean or anything. But I just sat in my chair, and at times we took a few breaks, and I had some discussions with her to kind of remind her. And at that point, some of the admissions had already happened.
Yeah.
And the bells had been rung, but I was trying to remind her, hey, remember we discussed this, remember we discussed that. And I think it was like kind of watching, it was kind of like a train wreck you couldn't stop. And at times, she could tell it was going terrible, and I was trying to get her through it and all that, but it just most of the time depositions don't like completely sink your case. That was one that did. It absolutely did. And it was tough because it was my client too. So we had to kind of deal with that later, trying to make it, trying to point out some of the weaknesses of the case without making it look like they're the one that messed it up. Because you didn't want to make them feel bad. You didn't want to put them in that spot. But that's the one that really comes to mind, and some of these nervous folks. I remember a guy had a photograph put, he said that the light was, let's say it was, red or whatever. It was a certain color at some point. And they put a photograph of him. It was a Google image of it happened to be right around where the accident happened. And you really couldn't see the light. But this guy insists that he saw the light. He puts his photograph in front of him, and he just switches everything. And I guess, no, I couldn't have seen it and all that. Afterwards, I talked to him. I said, you and I talked. You said you saw the light. Oh, I saw the light. I absolutely saw the light. What happened? He goes, well, he showed me that photograph. And I was like, just because you saw, you saw what you saw, and it was the same kind of thing. Intimidated, nervous. It just came out of nowhere, so that's tough.
And I think that's becomes one of the things that we find to be difficult as well, is that witnesses, as we would refer, get their amygdala hijacked, and they have that fight or flight moment when they're in the midst of it. And either they're going to fight or they're going to argue, like you said, like more of the angry witness, or you're going to flight and going to be the nervous person and just, I'm going to give you whatever you want. Just here, take everything. And I think that's one of the key things that a lot of clients don't understand as well is that when you have a situation like that, where you have a witness who you have a strong case, you think you're going to win, like you said, you're going to take it to trial and win 8 or 9 times out of 10. And then the witness goes in there, they're nervous. They haven't been, you do the legal prep and stuff, but you haven't addressed the psychological issues of it. And then they're thinking, oh yeah, this is going to be fine. I go in there, no big deal. And then they go in there and they, bomb the deposition. And before you know it, all of a sudden now what was a smaller demand now all of a sudden is a bigger demand. And I think reminds me of a case that, I had seen as well, where you had some medical professionals who did nothing wrong medically. They did not make a mistake medically. This was a case involving an anesthesiologist, a nurse, and a surgeon. In anesthesiology, and the nurse had done nothing medically wrong. The surgeon had made a mistake. The problem is the anesthesiologist and the nurse go in there and they, get emotional, and they start speculating on things, and they start giving additional information. And before you know it, plaintiff counsel says, you know what, now I'm going to pull my settlement offer that I have before. Now, you know what, I'm going to trial. And not only are we going to trial, I'm taking that deposition video of those anesthesiologists and that nurse, and I'm going to play it in openings, right? Because now I got some bad facts that I'm going to be able to play. So have you had any experience like that, or anything where your depositions have gone so far off the rails that from an emotional witness that it's then made that case become even more expensive than it would have been?
Well, that story I just said was one of them for sure. And yeah, I've had similar ones and it's normally, like I said, it's normally these folks that and a lot of times I feel like it's, when I have more institutional clients as opposed to individuals, most of the time they're the ones like they think they know things better than they do. And then they'll walk in, and there's been times where they've given some admissions, and it's just like, oh man. And like I said, the attorney looks at you and says, you know what just happened, right? And it's unsettling. And that's really, at that point, yeah, you're doing damage control. And those, if it's going bad in the middle of it, you try to do what you can to maybe find a way to take a break and kind of refresh and see if it just calms them down. And sometimes it does. And sometimes you get some reminders in there, but yeah.
It's hard, right? Once they get that emotional train rolling, it's really hard for it to stop snowballing and not become an issue. And once that happens, it's really, really hard to keep control, especially nowadays with these reptile tactics and stuff. And I know you have an attorney in Michigan who is very good at those, who shall remain nameless. But if you're a Michigan attorney, chances are you know who he is. But have you had any really run-ins with that as well, where you've had these reptile attorneys or these attorneys that have actually used these aggressive approaches to try to push the buttons of witnesses?
Oh yeah. Yes, I have. I just saw that recently. And it seems like you get them in, premises cases, like commercial auto cases, like maybe like ride share type, or, buses, trucks. And oh yeah, I remember I had one witness, and unfortunately this one was one where, I don't know if this falls into an emotion, but she was generally just disinterested. She kind of didn't care. And so she wasn't listening as closely as she should have been. And he was framing the cases as a matter of choices. Like, you made these choices. And it starts to make it look like you look a lot more reckless, and you look a lot more, just generally almost bordering on intentional. It makes it look really bad when you're acting with choices, as opposed to, hey, and I just was following too close. I made a mistake. It wasn't like my bad. I made a mistake. But it's funny. Yeah, they'll do that. And again, it's kind of like, the more even keeled the witness, the better they are, the better they are able to react to that. I would even say I generally do. You talk about like kind of angry folks. I find that I identify them. Usually, they're the easiest ones to identify, because they'll have no problem telling you how angry they are.
Yeah.
And then usually you can kind of calm them down by saying, listen, you kind of almost try to make it less personal for them. Get 10,000 feet, and a lot of times those folks, and also they're really angry. So I think they're very focused, and they usually do okay. Every once in a while I've had some anger kind of stuff pop out. I had a really nice farmer his company was getting sued, and one of his drivers that they've had him for years and they love him, but they were really trying to make him look like he was this bad guy because he did have, some stuff on his driving record, but it didn't bother him. And I remember he started snapping back at the lawyer because he, out of nowhere, I think he just got real angry. It got personal,
Yeah.
And, another kind of thing where, thankfully that one wasn't, he just kind of said some angry stuff back. Nothing that they could kind of use as a clip. But,
Yeah. That's always a bad sign, right? When a witness is trying to argue with an attorney, because that's never going to be something that they're ever actually going to win.
Yeah.
And that actually brings me up when you were talking about angry witnesses, as we found too, that angry ex-employee, that's always a fun witness to try to prepare, right? Talk about being emotional. They have no real motivation to want to be a good witness because they're pissed off at their company, and now they're angry that they're in the lawsuit and stuff, and now they become a complete nightmare, and who knows what they're going to say. I mean, I've seen before where cases have settled on the eve of trial because you have angry ex-employees who are about to get on the stand, and you don't, even if you think that you have them under control, you don't dare put them out on the stand and try to, who knows, and try to play a guessing game on what's going to come out of their mouth.
Yeah, that's a tough one, and a lot of those folks, they don't want to meet with you to prepare. They want nothing to do with you. And a lot of times you got to find something to make them care. If they will meet with you, you got to find a way to make them care.
Yeah.
And I tell you, it's really unsettling. Even when you can make them care, a lot of times they still, a lot of times they're just, even then, they're still disinterested and they aren't listening like they should. And the ones you're just kind of holding your breath on those, because there isn't a lot you can do with that when they start, a lot of times too, they're kind of testifying sometimes on behalf of your client, technically speaking, but they're an adverse witness, and you're just, those don't go well.
Yeah.
Those don't go well.
So kind of bring us home then with a few nuggets to take home for the listeners as far as those people out there who are getting ready to prep emotional witnesses. Kind of what are your approach to it, and what are your thoughts as far as how to handle that?
Yeah, I mean, I think you identify when you have somebody that's emotional, whether it's, it's an individual you're representing and it's your client, or it's an organization where there's multiple, maybe there's going to be multiple people that are going to be represented and defended at these depositions. You want to identify who's emotional and what the emotions are. And that's probably the number one thing. Because when you've got those identified, then you can meet with them, you can sit down, you can connect with them. And that's one thing, you want to identify, are they angry? Are they nervous? Are they sad? And kind of find that issue and meet with them and connect with them and meet with them a lot. Have maybe an initial meeting. That's a lot of times when the folks sometimes will let it out to you. Make sure you make it clear to them. Especially in instances where they are your client, it's privileged. Make it clear they can tell you everything, and don't be afraid to pry with them a little bit to see if there's something there. And then, like I said, connect with them and see what's making them upset. Try to make it less personal. What's making them emotional or sad? And like the young woman I talked about, I mean, I made it clear to her, you didn't do a darn thing wrong. And I tried to make it too, like, don't hate this guy. This guy's got a client to represent. He's going to question you. Even in that one, he wasn't really always the nicest, but he, and he was good with her. But I said, listen, even if he's not nice to you, this is not personal. He's got a client to represent. Or what's making you nervous, and try to comfort them with explaining the process, what might come up, that sort of thing. And you meet with these people a lot. A few times if you can, and I think that kind of will kind of help chill them out. I think also if you have any level of a relationship with your opposing counsel, it's good to kind of, and they're not going to use it. It's good to give them the heads up, because I know, and certainly sometimes I'll be made aware of it, and sometimes I'll just pick up on it. When people are emotional, I try not to, especially when it's ones where they're really nervous or they're really upset and sad. Because it doesn't really do, in my opinion, if it says it's an opposing witness, I don't think it does me any good to make this nervous person to try to, make them, really kind of run all over them, or if they're sad to make them extra sad. I think most people will hear that and say, okay, thank you for letting me know, and I will, and then therefore you have your antenna up and you try to make your questions so that you're getting what you need, but you also are avoiding at times unnecessary issues like that. Because really at the end of the day, you really want to get through it. You want to get the testimony. And then I think when you're in it, when you're in the midst of it, you gotta, hopefully, like I said, hopefully you're ready for it. But even if you're not, if you start seeing folks get angry, get flustered, make sure you just say, hey, listen, let's take a break. I always have a thing in my prep when I'm prep my witnesses. I explain to them, you're allowed to take breaks. And so that could be a real break, like you've been sitting there a while, you got to use a restroom, you need to have a drink. It also could be a break like you're nervous, you're upset, we're going down a road that we never kind of talked about. And I said, and if I ever ask you if you need to take a break, the answer is always yes. Okay. Yeah. Don't say, oh no, I'm good. No, it means I'm noticing something. Yeah. And right now we're doing a lot of Zoom depositions. I find that to be a lot harder to control the situation a little bit, to say, hey, let's take a break. You kind of grab them and get them out of there. Yeah.
Hey, let's take a break.
Yeah. I'm good with putting my hand up. You can kind of do things almost like a nonverbal barrier, so we'll hopefully get back to that sort of stuff soon. But, even I think on Zoom, you got to be more attentive to that and just kind of whoa, and say, we need to take a break and let's talk, and grab your phone and cell phone and get them on the phone and talk with them, but identify it, take breaks. If opposing counsel's using those emotions to try to get, because I tell my witnesses, I said, listen, they're going to try to make you angry. They're going to try to make you upset. They want you to start answering questions without thinking, because that's when you get into trouble, when you aren't listening to the whole question. And they want you to start giving them stuff that you maybe wouldn't normally give them, because you aren't, you're kind of out of your head a little bit. And when, and so if I see counsel trying to do that, I will try to jump in and protect them and let them see that I'm protecting them. But at the end of the day, you got to try to maybe take breaks, sit down, calm them down, and then hope you get through it, and hope that the end is near,
I think you brought up something else that it made me start thinking, because you brought up Zoom depositions. We're still kind of hopefully getting around the corner and on the downswing of COVID-19, and we'll get back to kind of normal. But I think one of the things to keep in mind as well, right, is that we have these witnesses who are going to be coming in who are impacted by COVID-19 and have had experiences, or loved ones who have died from COVID-19, or just all of this motion that we're talking about already, that's already started. Now it's compounding more by COVID-19. So I think it's going to be another thing as well, right? When you go in to start talking to your witnesses, is that it's another factor that's in the back of their mind, especially soon, I'm sure, when the courts start opening and you're going to start seeing cases. I'm sure you're going to start seeing cases related to COVID-19 deaths. Now you're going to have emotion built on emotion as well.
I think there's that for sure. And I think you're going to have, if you think about just the process of being in person with folks, I recognize there's folks out there, hey, this is no big deal, and it doesn't bother them. But there are a lot of people that are afraid to leave their house right now. And, and when we get in person, it's going to be a little bit, it's going to be a little bit foreign. And I think it's probably going to be important to identify, are you comfortable with this? Mm-hmm. And if they're not, make them comfortable. Maybe you find a way to do it by Zoom, but you're next to them, that kind of thing, and I know there are a fair number of attorneys doing right now who still have, offices open and things like that. They are making sure they are with their client. But yeah, you're going to be dealing with, It's going to come up in various ways, in terms of either whether it's the subject matter of the lawsuit, or let's say it's a case where you have somebody, the plaintiff is claiming someone took care of them, or there's an important witness, there's an important person that we're going to have to talk about, and maybe you lost them, maybe you lost them because of COVID. And we're going to have to say, listen, I kind of harken back to preparation, which I know is kind of, that's the way really at the end of the day to probably get through all of this. And there's an example of identifying there's an issue. You let them know it's going to come up. Get mentally prepared for this to come up. Get ready for how you're going to answer it. Get ready for how you're going to feel. And don't worry, we can take our time and we can take breaks, and just calm them down and kind of let them know how this is going to go. But yeah, you're right. It's going to come up in a number of ways, and we're going to have to be aware of that.
Yes, absolutely. So Matt, great talk. I appreciate you being on. If someone wants to get a hold of you, if they have questions or want to talk more to you, how do they get a hold of you?
Probably email or phone. My email's matthew.labeau@ceflawyers.com. My phone number, our office has been closed, but I do get my office number, so I don't always give that out anymore because I forget it. But it's 248-663-7724. I'm always happy to take calls and emails, and I do a lot of continuing legal ed in Michigan, and I have lawyers call me on stuff or other folks like that, and I'm happy to take a couple minutes and kind of share my thoughts. I think we owe it to the profession to work together on stuff like this, and so I'm happy if anybody needs any input or help. I'm happy to do it.
That's a great answer. That's one of the things actually we've been harping on, right? Is the defense bar needs to start getting better as far as communicating with one another and collaborating, because right now plaintiff's bar is doing that, and plaintiff's bar is ready to come out of COVID swinging and hitting these big dollar verdicts. So I think the defense bar needs to start doing that a little bit more and collaborating. So I think that's awesome. And if anybody needs anything from me, I can be reached at swood@courtroomsciences.com. Like I said, Matt, appreciate you being on. Hopefully have you on again. Look forward to talking to you more on a different subject at a different time. This has been another edition of the Litigation Psychology Podcast. Thank you for listening.